afternoon, Deputy City Attorney Jennifer Hanslick from the Labor Relations Division.
Good afternoon.
Members, you have a report from your CLA, which on page 13, or 11 rather, specifically addresses the steps, and I offer that to you as a written document to follow along as I discuss unilateral implementation. It's actually bullet pointed for you, and this is pursuant to the city's employee relations ordinance that sets forth the process of what steps have to be taken for unilaterally implement. You have to go through a negotiation process. There has to be a good faith opportunity for exchange of proposals, and you have to get to a point where it's clear that the parties are not able to reach agreement. Then at that point, the city would present what's called its last, best, and final offer. And only when IBEW or any union formally rejects the offer, and then there's some period that passes, the city could declare an impasse and file with the city's labor board, the city's employee relations board. At that point, the ERB would appoint a hearing officer. ERB, excuse me, again, for the general public, is the city's labor board. The city's labor board that oversees labor disputes between the city management and the labor unions would appoint a hearing officer, and there would be a series of hearings on the validity of the proposals being exchanged, not the validity, but whether the parties are in fact at an impasse. The hearing officer would tell the board, well, we think that the parties could talk some more and possibly get to an agreement. This would require an assignment of a hearing officer, hearings, and then a decision by the labor board. So again, a multi-stage process. If in fact there is an impasse, the board has to make a finding that the parties are at impasse. There's a stalemate. No further discussions would be fruitful to reach an agreement. The board would say, okay, we're going to appoint a fact finder and gather information from the parties to determine whether the validity of the reasonableness of their positions, whether or not that there is a reasonable basis for the parties' positions that they can't reach an agreement. The information would go to a mediator, and the mediator would then sit down with the parties and try to work something out. Ultimately, after all of these steps, a contract can be imposed. But then there's also the potential of legal challenges for that contract. When an entire contract is an issue on an expedited basis, it would take at least 6 to 9 months to complete this entire process. Again, under an impasse procedure, you can only implement for 1 year. So 6 to 9 months would go by, we'd unilaterally implement, and then we'd be back at square one again. So, to recap, the potential to go specifically to Councilmember Krikorian's question, the potential to get 3 years of zeros with a unilateral implementation would be extraordinarily cumbersome and time-consuming, and as has been mentioned already, very distracting to the rest of the city's business.
And I presume that each one of those declarations of impasse and each one of those unilateral implementations would be separately subject to litigation.
That is true.
So
yes.
for 3 years, we would be facing 3 separate potential lawsuits in which a court comes in to determine whether the reasonableness of the parties' positions in labor negotiation. We'd have to litigate that issue.
Correct. So there's a potential for a great deal of uncertainty if it's a route of pursuing 3 years of zeros through an impasse course of action.
And what would be the ramifications if a court were to find that the city's position was unreasonable, or that impasse was improperly declared, or that we were incorrect in the process of getting to unilateral implementation?
Well, then we'd be back at square one, and we'd end up having to revisit all of the issues all over again.
Okay. Any